Hi everybody, this is Jack Meligan with you again from the Plaintiffs MSA and Lien solution. Well, Medicare has done it again. Yet another trial lawyer firm punched in the nose by Medicare. The latest, just a couple of days ago, the Department of Justice levied a $90,000 fine against Baltimore, Maryland attorneys Saints and Kirk. The issue, once again, it was involving Medicare conditional payments and evidently this law firm's mishandling or failure to handle properly and resolve properly the Medicare conditional payments amounts for one of their clients in one of their cases. Now, what is especially interesting about this case, number one, it's the third set of trial lawyers that have been punched in the nose over Medicare issues. This is the third time that a trial lawyer has entered into a settlement agreement with the Department of Justice. This is the second time that the U.S. Attorney for Maryland, Robert K. Herr, who you can see behind me here, I found a picture of him, good-looking young guy, but he's the U.S. Attorney for the District of Maryland, and in the previous case, $250,000 fine. That was Robert K. Herr. We talked about him in a previous video. Once again, we have Attorney Herr involved in this particular case, and he made a statement that, well, it should cause every plaintiff's trial lawyer in the country pause. And let me read it to you. Here it is, quote, "Plaintiff's attorneys cannot refer a case to or enter into a joint representation agreement with co-counsel and simply wash their hands clean of their obligations to reimburse Medicare for its conditional payments." He went on to say, "We intend to hold attorneys accountable for failing to make good on their obligations to repay Medicare for its conditional payments, regardless of whether they were the attorneys primarily handling the litigation for the plaintiff." So this is a big one. Now, you've referred the case to another attorney, and that attorney does not handle the Medicare conditional payments resolution properly, you're now liable. You are co-counseled into a case, and lead counsel that brought you in, that was their responsibility to handle Medicare conditional payments resolution for that client. Not so fast. You're not off the hook. If they don't handle it, you're now, according to this, you now can be held liable. So, what's the lesson in all this? Well, there's several. Number one, as we've talked about before, we have many pieces of evidence going back over the last 2 years that the government, and specifically Medicare, CMS, are pivoting to liability cases. They have upped the capacity of their review contractors, their recovery contractors, to review liability MSAs that could be submitted in the future. Even though they haven't issued guidance on voluntary review, they've upped their capacity to 51,000 cases. That's one big issue. So we know they've pivoted in that direction. We also know that through these actions where they have now punched 3 different sets of trial lawyers in the nose over the mishandling of Medicare conditional payments, that they are ratcheting up that enforcement mechanism, and this is a new level where the co-counsel or the referring counsel can be held liable. That's incredible. I mean, if you look at this on an evolutionary timeline, you have to agree, you've got to be able to acknowledge that the government is stepping up their efforts to enforce their secondary payer rights and to recover these conditional payments. The other thing that we know from the last 2 years of activity is that Medicare and CMS have come to the conclusion that any amounts that they have erroneously paid that were not repaid in the form of conditional payments, any amounts they paid, even post-settlement, Medicare CMS can consider those conditionally paid, and they have already shown in several cases that they will come back after them. Now, again, we've also talked about how Medicare is still one of the most disorganized bureaucracies in the United States government, but they're getting their act together. They've got now 7 years of data on settled cases. These are Section 111 reports from the defendants that you've settled with or the self-insureds. They know the amount of the settlement for your client, they know the date of the settlement, and they know the ICD-9 or 10 codes that were settled, and that gives Medicare CMS the ability to run a match when your client's treaters in the future send in a bill, and it's coded, because everything's coded nowadays. You can't get treatment anywhere for anything without codes being registered on the bills. But those codes are then matched in your client's common working file at Medicare. If there is a match, your client's treaters are going to get a denial of payment letter, which means the treaters are going to send your client the bill as per their agreement, their service agreement, which means if your client is out of money, you're probably going to have a client that's panicking, maybe unhappy, they may call you. So, other big lesson here is that if you've been ignoring this conditional payments problem, you've got to change your process. Ignoring the problem is not going to make it go away. It's bitten 3 attorneys already, the latest a $250,000 fine, and don't forget, all the previous cases, including this one, have signed settlement agreements where they have agreed with the government that they will guarantee, that attorney will guarantee that somebody in their firm is specially trained to handle conditional payments in a timely manner, that the attorneys will review at least every 6 months the processes and address any cases that are not resolved, and these attorneys are agreeing that should they ever drop the ball on a Medicare conditional payments issue again, they may be subject to a Federal False Claims Act charge and up to treble damages. It's getting serious. So, final point, this whole Medicare conditional payments issue is complex. We understand from talking to you trial attorneys, and especially your paralegals and legal secretaries who call us, that it's a major problem in your offices. Your staff doesn't like handling it. Many attorneys don't like handling it. You're worried about the liability issues. Did you do it correctly? Did you cover everything? Are all the T's crossed and the I's dotted? There's a simple solution for that, and this is a toot our own horn solution, but we offer the country's most comprehensive Medicare conditional payments resolution service. We suggest, as a change to your process, consider outsourcing this to us or a company like us that handles these kinds of issues and will resolve the conditional payment situation for your client at the absolute lowest dollar possible. Remove that work process from your office and all the stress and liability, handle it for you, deliver it on or just after your case is settled or verdict obtained, so that you can then get a final demand from Medicare in a very timely basis, much shorter than reporting this on the date of settlement and waiting up to 90 days or more to get your conditional payments demand letter. We do that. That's a service we offer. Consider outsourcing this and taking it out of your firm so that you, your associates, and your staff can turn their attention to much less stressful things and much more productive things in your firm. That's it for today. This has been Jack Meligan for the Plaintiffs MSA and Lien Solution. If there's anything we can do for you, please call. We'd love to talk to you about your situation, help you adjust your process, and show you the difference that it can make when you outsource these types of resolutions to a firm that does it all day, every day, and has people who live, breathe, and sleep dealing with these Medicare issues so that you guys don't have to. Talk to you soon. Take care. This has been Jack Meligan for the Plaintiffs MSA and Lien Solution.